Very good. Very good. We're going to get started. It's great to see everyone here. Thank you for all of you who have come in person on this lovely fall day in Ann Arbor. We are very pleased to welcome you and some hundreds of virtual attendees, and I'm sure that there will be more in the future due to the archive version of today being provided on the website of the Center for the Assessment of Tobacco Regulations shortly after we're finished today. This is the first edition today of our new Distinguished Speaker series from the Center, which we refer to as CASTOR. And I'm a member of the CASTOR team. I'm Cliff Douglas, also serve as the director of the University of Michigan Tobacco Research Network and as an adjunct professor at the School of Public Health in the Department of Health Management and Policy. And we are delighted to have today as our inaugural speaker, Mitch Zeller, who is the recently retired director of the Center for Tobacco Products at the U.S. Food and Drug Administration. He'll be receiving a fuller introduction shortly from Dr. Richard Miech, whom you will meet. And after Mitch has spoken today, we're delighted to have serving as a respondent Dr. Jamie Tam, whom I will also introduce more fully later, who has spent some time at the FDA and is now a professor at Yale University. So following those talks, we're going to welcome some Q&A in the remaining time. The Q&A will be accepted from our in-person audience only. And in the meantime, before we move ahead, I just wanted to share a few acknowledgments for our event today. First of all, we have had a wonderful event planning committee, including the principal investigators from CASTOR, Rafael Meza, and David Mendez, David Levy from Georgetown University. We also have Royan Sun, Jamie Tam, Ken Warner, and Richard Miech. We also want to thank our School of Public Health, which supports our center and research activities. Monitoring the Future, for which Richard Miech is a leader, and they are a co-sponsor of this event. The Rogel Cancer Center for generous ongoing support of our center and junior investigators. CASTOR itself, it has a very large team of PIs, investigators, researchers, students, staff, and so on. And it is a partnership of Georgetown University and Yale University, along with Michigan. There's also the CASTOR event staff for your organization and volunteer support. Our student escorts, all important student escorts, Chris Cadam, Kara Kiesling, and Luis Zavala, who will be spending time with Mitch Zeller over the next day or two, escorting him and learning from him. And I hope, Mitch, that you learn from them as well. And then Michigan Media for providing the videography and live stream service today. So with that introduction, I'd like to welcome Professor Rafael Meza to the lectern to share some further thoughts.
Good morning, afternoon, everybody. Thank you for joining us. I'll be brief. I just want to thank you all for joining us. Of course, thank you, Mitch Zeller, for accepting our invitation to be the first speaker of this distinguished seminar series. On behalf of the CASTOR principal investigators, David Mendez, David Levy, and myself, and our three institutions, University of Michigan, of course, Georgetown University, and Yale University, I want to welcome you and thank you. Briefly, the Center for Assessment of Tobacco Regulations, CASTOR, is one of 9 FDA and NIH sponsored centers, tobacco centers for regulatory science, that we are, conducting a lot of the research and science to support FDA's hard work of regulating tobacco products. CASTOR focuses on modeling and data analysis, epidemiology, and quantitative projections of what might be the impact of potential and current tobacco policies and regulations. And as such, for us, it's a pleasure and an honor to welcome Mitch Zeller, and so we can learn about everything that I guess is needed and the challenges of regulating tobacco products from the regulator perspective. And so we welcome Mitch Zeller. And without further ado, Professor Richard Miek, who is a professor at the Institute for Social Research and principal investigator of the Monitoring the Future survey, will give an introduction of Mitch Zeller.
Wonderful.
Thank you, Raphael. Mitch Zeller led the FDA Center for Tobacco Products for 9 years, from 2013 to 2022. And during his tenure, succeeded in reducing disease and death from tobacco use and bringing previously unavailable information about its dangers to light. Mitch was, and is, even though he's 6 months retired, dedicated to carrying out CTP's charge to reduce the harm from all tobacco products across the entire population, with focus on how and why people start, stop, or restart using these products. Mitch is a graduate of Dartmouth College and the American University Washington College of Law, and has been working on FDA issues for more than 30 years. He began his career as a public interest attorney in 1982 at the Center for Science in the Public Interest, and in 1993, he joined the staff of then FDA Commissioner Dr. David Kessler, and then up serving as Associate Commissioner and Director of FDA's first Office of Tobacco Programs. He was instrumental in crafting the agency's 1996 tobacco regulations. And what a time that was in the 1990s. Mitch has also represented FDA before Congress, federal, and state agencies. In addition, Mitch served as an official U.S. delegate to the World Health Organization Working Group for the Framework Convention on Tobacco Control. On a personal note, I have been enormously impressed with Mitch since the first time we came in contact. That contact took the form of an email from Mitch in which he sought information from my team on national estimates of adolescent vaping from the project Monitoring the Future, for which I'm the principal investigator. Here was a person very influential in the policy world, seeking out data to inform his decisions. And it became clear that he was taking a close, detailed look at the data, comparing estimates from different national samples to see if they were coming up with the same answers and if they were robust. And he asked probing questions. This is the way it should be, I think. And I definitely know it's not the way it always works, where some people disregard all data and facts as they make policy decisions. And so with that, I'm happy to cede the floor and introduce Mitch Zeller. Thank you.
Thank you so much. Do you need to turn this other microphone on? Okay. Well, Richard, David, the other David, Cliff, and everybody that is responsible for getting me here and putting together this amazing several days of talks and informal discussions with faculty and students. I'm honored, I really am. And to be the inaugural speaker in the series is a further honor, and I'm greatly appreciative. In conversations with Cliff and others in the weeks and months leading up to this talk, we thought that it would be most helpful now that I am no longer a Fed, even though I can't share non-public information still, I take that to my grave. But I am now a private citizen, and it gives me the opportunity to say some things and to share some views and opinions that kind of had to keep to myself for the last 9+ years as center director. And so we have fashioned this as a look backwards and a look forward when it comes to nicotine and tobacco regulatory policy. Some of this is going to involve getting in a time machine going back in time with me a number of decades to look at things through an industry lens. Join me on this journey. I've divided the talk into 4 sections. The first, even before we get into the time machine, is to try to make the case for tobacco product regulation. Then we're going to go back into the past and take a look at what the industry said and what they knew about nicotine, and just as important, when. And then we'll come further up to present time, things that we tried to do at FDA when it came to tobacco product regulation in the 1990s, and then Congress ultimately having to step in. That'll take us to the present, where we'll take a look at the marketplace for nicotine today, talk about some promises, talk about some challenges, and talk about harm reduction issues in the context of, okay, it's now a regulated marketplace, including pre-market review, which I will explain in a few minutes. What does that all bode for us? And then no crystal ball, but I'll share some observations looking forward. Talk about one of the potential endgame strategies, reducing nicotine in combustible tobacco products. Share a series of questions that I've been posing publicly for a number of years, and then close with some reflections. And this is a very US-centric talk. Close with some reflections on the current debate on harm reduction in the United States. But first, let me try to make the case for regulation of tobacco products. And in order to do that, we have to have some picture of, well, what was it like in the historically unregulated tobacco marketplace in the United States? Because but for 3 short years in the late 1990s, there was absolutely no regulation, federal regulation of tobacco products in the United States in the 20th century. And so what happened in that historically unregulated marketplace? Well, for one thing, the companies were extraordinarily successful at denying that nicotine was addictive and denying causality when it came to illnesses associated with tobacco use. It was a strategy that they adopted and successfully implemented for many, many years. When previously secret internal industry documents began to emerge in the 1990s, we got an insight into how the companies thought about this strategy and the tactics that come with them. And one of those sets of insights comes from a project at what was then the 3rd largest cigarette company in the United States, Brown & Williamson, or B&W, ironically titled Project Truth. And one of the most famous quotes from all of those secret industry documents that started to emerge is this one sentence: "Doubt is our product." What they realized was they didn't have to disprove addiction. They didn't have to disprove causality. They just had to inject enough uncertainty and enough doubt every time there was a health scare, primarily associated with cigarettes starting in the 1950s, to maintain this posture of denial. And as part of Project Truth, this company was explicit about what their objectives were: to set aside, in the minds of millions, the false conviction that cigarette smoking causes lung cancer and other diseases, a conviction based on fanatical assumptions, fallacious rumors, unsupported claims, and the unscientific statements and conjectures of publicity-seeking opportunists. And while this was written in 1969, it was 1969. It wasn't like 1910 or 1915. This was close to 20 years after the EPI started to emerge from the United Kingdom, 5 years after the first ever Surgeon General's report tying smoking to cancer in the United States. And this is where Brown & Williamson was in 1969. So, in that historically unregulated marketplace, faced with an industry that was successfully denying health effects, and in the absence of a regulator, it was the companies that decided what products got introduced to market. It was the companies that decided what, if any, modifications would be made to products on the market. And it was the companies that decided what, if any, claims would be made for the products. And we, as a society, paid a public health price for this. The consequences from the historically unregulated marketplace were profound. Because every time there was a health concern, starting in the 1950s, and in the absence of regulation, It was an industry response, primarily with some sort of modification to the product to try to allay the health concerns that had come out. In the 1950s, it was the advent of the filtered cigarette. And what that gave us was the amazing case of the Kent micronite filter, a filter that was lined with asbestos. So that when smokers were smoking the Kent filtered cigarette, in addition to inhaling tobacco smoke, they were sucking down asbestos fibers. In the 1960s and the 1970s, the so-called modification was the light and low tar cigarette, which is probably the greatest fraud and deception that has ever been perpetrated on the American public in the history of consumer products. The light and the low tar cigarette was specifically designed to lower tar and nicotine deliveries when measured by a machine. But when the companies came up with this so-called innovation, they knew that human beings smoked very differently than the machines, and that when human beings smoked these cigarettes, the tar and nicotine levels went up. But that's what happened for the better part of a century, in the absence of independent science, in the absence of regulation. And at the time, government and health authorities assumed that there was a public health benefit from these innovations, not knowing any better. So what do we get with product regulation? Well, you get a federal regulatory agency, the Food and Drug Administration, that serves as a gatekeeper, if you will, in the same way that FDA has historically played this gatekeeping role for the regulation of foods, drugs, medical devices, et cetera, standing between the tobacco industry and the public. So instead of decisions about marketing being made by product developers and marketers at tobacco companies, all of the decisions about new products and claims that have a potential to come to market are made on a science basis by an independent regulatory agency and the scientists at the Food and Drug Administration, not the tobacco industry. And the law, as I'll lay out shortly, makes clear that the legal burden rests with the companies to demonstrate that marketing is appropriate under whatever the relevant statutory standard is. And I will concede that in some cases, the standards that Congress wrote into the law that is now on the books is high. Okay. I'm not trying to persuade you that regulation is good, but I did want to make the case for it before we get in our time machine. And so come with me now back to the period in time where we'll see what the industry said about nicotine and when. And our first stop is going to be in the year 1963. 1963 was 1 year before the first ever Surgeon General's report in the United States, right? But for our purposes today, 25 years before the Surgeon General of the United States was finally able to conclude that the nicotine in cigarettes was addictive. That didn't happen until the Surgeon General's report of 1988. In 1963, a lawyer named Addison Yeaman, working for that third largest company, Brown & Williamson, wrote, "Nicotine is addictive. We are then in the business of selling nicotine, an addictive drug." And I regularly use this quote in talks because it is profound to me. Profound in as much for what it doesn't say as what it does. Remember, this was a lawyer for a company, not a researcher or scientist, and he was already conceding privately and behind closed doors that nicotine was addictive. But it's what he doesn't say here that I still find amazing to this day. He didn't say they were in the cigarette business. He didn't say they were in the tobacco business. He said that they're in the business of selling nicotine, an addictive drug. What about the other companies? This is a now infamous quote from a Philip Morris executive in 1972. The cigarette isn't a product, it's a package. The product is nicotine. The pack is a storage container for a day's supply of nicotine. The cigarette is a dispenser for a dose unit of nicotine, and a puff of smoke is the vehicle of nicotine. Keep that notion of dosage, dose units, and vehicle in mind as we come up to today, especially as we start talking about e-cigarettes. R.J. Reynolds in 1972, in a sense, the tobacco industry may be thought of as being a specialized, highly ritualized, and stylized segment of the pharmaceutical industry. Tobacco products uniquely contain and deliver nicotine, a potent drug with a variety of physiological effects. Reynolds also had some amazing insights into, first, what they call the so-called confirmed smoker, whose choice of product and pattern of usage primarily determined by individual nicotine dosage requirements. Our industry, based upon design, manufacture, and sale of attractive dosage forms of nicotine. And Reynolds also had some insights into the so-called pre-smoker. Think about that concept, a pre-smoker, or the non-smoker. And Reynolds wrote, the things which keep that confirmed smoker, look at the euphemisms here, habituated and satisfied, unknown or largely explained to the non-smoker. Only after experiencing smoking for some period of time do the physiological satisfactions and habituation become apparent and needed. We must somehow convince this pre-smoker or non-smoker with wholly irrational reasons that they should try smoking in the hope that they will discover the real satisfactions, in quote marks, obtainable. British American Tobacco put it very succinctly in 1980. BAT should learn to look at itself as a drug company rather than as a tobacco company. And finally, the now defunct Tobacco Institute, the trade association in the US that represented the industry for decades. In 1980, they wrote, the entire matter of addiction is the most potent weapon a prosecuting attorney can have in a lung cancer cigarette case. We can't defend continued smoking as free choice if the person was addicted. So that's what they said about nicotine. That's when they said it. Now, what did they know scientifically about nicotine and tobacco smoke? And just as important, when did they know this? And for this, and sorry about the small print here, we're going to take some quotes from previously secret internal Philip Morris documents. This first document is entitled Development of Practical Methods for Modifying Cigarette Smoke to Give Minimum Lung Retention. And according to this document, a couple of Philip Morris officials visited a contract research organization, Battelle. And on that visit to Battelle, according to this document, they asked for a proposal to study practical methods whereby the particle size of cigarette smoke might be altered to minimize lung retention. And this document was that proposal, describing a plan of research that would be followed when attacking the problem of altering the particle size of cigarette smoke with a view to reducing lung retention. So that's the what. Now, what about the why? Why did Philip Morris and Battelle collaborate on this? And here's the answer. Well, first of all, it started with this remarkable insight into smoke chemistry. So they wrote, cigarette smoke is comprised largely of particles approximately 1 micron in diameter. And they said that that was a size that was near the optimum for retention in the lungs. But what Philip Morris and Battelle realized was that that was a public health dilemma for them. And these next quotes have some euphemisms, but it's not hard to see through the euphemisms. So what they wrote was that 1 micron diameter particle size was undesirable in that retention of tar particles is high, tar particles being the cover statement for all those compounds in smoke associated with cancer, lung disease, and heart disease. But desirable in that there's maximum retention of physiologically active components. And the companies recognized that there was an imperative here. And the imperative was to preserve the physiological response. If the size of the smoke particles were to be changed, alternative means might be required to increase the alkaloid content, read nicotine, increase the alkaloid content in the smoke. Battelle got very busy, and they followed up at a certain point with outreach to the then vice president for research at Philip Morris. And Battelle said, guess what? How about developing what might be termed an instant cigarette, where the physiologically active components could be dispersed in the form of an aerosol through a meter device in such a way as to simulate a puff of a cigarette. Sound familiar? And Battelle went on to say, no euphemisms here, by the way. Well, this is going to require an understanding of some of the addictive aspects of nicotine and the associated alkaloids. The important consideration is not tobacco, but the reaction resulting from the nicotine. And Battelle touts how great their lab is and how great the Philip Morris lab is. And then they say, in order to get the physiological reaction, it will be extremely important to have the particle size such as to yield rapid absorption through the lung. And Patel concludes, as long as the system achieved its quota of nicotine, remember, dose unit, vehicle, et cetera, from the earlier documents, it would make little difference whether the alkaloid was secured from smoke or from a mist. Okay, so that's what they said about nicotine and smoke chemistry. And the question is when? When did Patel begin the particle size research that Philip Morris tasked them to do? When did they submit that proposal? When were there subsequent internal discussions at Philip Morris? And when did Patel propose something that sounded very much like a prototype for the e-cigarette? And the answer is in the 1950s. That, according to those documents, which are from the 1950s, that research began at least as early as 1957, if not earlier. The proposal is dated and was submitted in 1959. Internal discussions at Philip Morris ensued in 1959. And the description of what has become the e-cigarette was suggested in 1959. And so where does that leave the regulator? So, fast forward almost 40 years, and what we were doing in the 1990s at FDA when we were putting together the case for regulation of tobacco products was to play catch up. I mean, look at what the industry knew about nicotine, how long they knew it, and how long they applied that to the design and the manufacture of an incredibly toxic, deadly, and addictive product. They had a 50-year head start on us. And we've been playing catch up with the industry ever since. Now, in order to assert jurisdiction over cigarettes and smokeless tobacco products in the 1990s, we had to overcome what was called the flavor and taste argument. Remember, this is still in the decades of denial of addiction and causality. The industry didn't deny that nicotine was, in their words, an important part of the smoking experience. But their argument was that the significance of nicotine, ironically, because it has an awful flavor and taste, their argument was the significance of nicotine was its flavor and taste. So we had to overcome the flavor and taste notion, which we did through use of the kind of internal industry documents that have been kept secret for decades that began to emerge coincidentally with the launch of our investigation in the 1990s, through discussions with confidential informants, some of whom were still working for the cigarette companies at the time, some of whom had retired, and through our own independent investigation, where we were able to conclude that there were many different ways to independently manipulate and control nicotine levels, whether it's through the blending of tobacco leaves with varying nicotine content, smoke chemistry manipulation to alter the pH of the smoke to affect nicotine delivery, or just genetic modification of the tobacco plant to either raise or lower the nicotine content in the ground. So we gathered all that up and we asserted jurisdiction in 1996. 15 minutes after our assertion of jurisdiction was made public, we were sued in 4 different federal district courts by tobacco advertisers, manufacturers, growers, and retailers. All those cases were consolidated into one case that made its way to the Supreme Court. Because of the ongoing litigation, there was only very limited regulation of tobacco products during this period of time. Basically, a 3-year period where, in essence, all we were doing was enforcing youth access restrictions. It was historic, it was a first, but that's all we were doing. And we waited for this case to go to the Supreme Court, which it did. And I sat in the Supreme Court in early 2000 and watched the case for FDA regulation of tobacco products be argued. And I, with all of my FDA and federal colleagues, watched and saw that we were going to lose. It was just a question of how bad we were going to lose. I was one of the only people that thought it was going to be close. That doesn't matter because we still lost. And in a decision known as the Brown and Williamson case in 2000, in a 5-4 decision, the Supreme Court overturned the FDA assertion of jurisdiction. And what that meant was everything that we had built, you heard in the introduction that we created a small office of tobacco programs that I was running. We were doing the youth access restrictions. We were looking into some harm reduction issues at the time with smokeless tobacco. The whole thing had to be shut down. And the essence of the Supreme Court ruling came down to these notions. Supreme Court said, well, FDA's asserted jurisdiction to regulate an industry constituting a significant portion of the American economy. and this next sentence is just a gem, owing to its unique place in American history and society, tobacco has its own unique political history. This is the United States Supreme Court. And so they concluded that Congress has not given the FDA the authority that it seeks to exercise here. I must have missed those days as a government and policy studies undergraduate and as a law student. Tobacco has its own unique political history. And 5 justices of the Supreme Court used this as a basis for saying, FDA, you do not have the legal authority to regulate tobacco products. But that's what they did. And they said, bottom line, Congress, you decide as a political act through the legislative process if FDA should regulate tobacco products. And so we waited and waited. And Congress stepped in, but it took them 9 years. And we had almost another decade of the unregulated marketplace. But in 2009, Congress passed the Family Smoking Prevention and Tobacco Control Act, or the TCA, as we call it. And it's a lengthy and complex piece of legislation that lays out vast number of different authorities that FDA has to regulate tobacco products. Don't have time to go through all of them, but I do want to talk about something that I mentioned earlier related to pre-market review, because that's important to our discussion about the marketplace today. Because when it comes to new products or new claims, the legal standard that Congress wrote into the statute that ultimately is being applied to e-cigarettes and other so-called electronic nicotine delivery systems is whether the marketing of the product or the authorization to make a claim is, in the words of the statute, appropriate for the protection of the public health, or APPH for short. And in the statutory and legal framework that Congress created in the TCA, these are supposed to be case-by-case decisions based upon the evidence that is submitted by the applicant in an application. And it's up to the companies to demonstrate that the benefits to adults outweigh the risks to kids, especially when it comes to flavored products. So this is not some kind of categorical approach, e-cigarettes good, e-cigarettes bad. Heated tobacco good, heated tobacco bad. Smokeless good, smokeless bad. These are case-by-case, literally product-by-product determinations. And it is clear from the law that the legal and the evidentiary burden is squarely on the company. Armed with what we called the final deeming rule in 2016, we finally had regulatory authority over e-cigarettes and other products where the nicotine was derived from tobacco but had previously been unregulated. And so this framework for pre-market review is what's being applied to the review of applications for e-cigarettes. Okay, fast forward to today. Well, it's a marketplace for nicotine. That guy, Addison Yeaman, that lawyer for Brown and Williamson, he was right. It was a marketplace for nicotine then. He admitted it in that amazing 1963 quote. And it remains a marketplace for nicotine today. But there's a huge change. Because today, the nicotine can be delivered into the lungs without having to burn tobacco leaves and inhale the smoke. And that's a huge difference from 1963, because the nicotine in these products, while not a completely benign compound, doesn't directly cause the cancer, lung disease, and heart disease. Yeah, the nicotine got you addicted and kept you, when it comes to combustible products, kept you smoking. But it's that repeated exposure to those 7,000 chemicals in the smoke, dozens of which have been identified as causing cancer and lung disease and heart disease, that kills, not the nicotine. But nicotine doesn't get a free ride here, because depending upon the vehicle, it can be incredibly addictive. And no kid should be inhaling nicotine into their lungs. And when you throw in the whole flavors issue, we have a real set of population-level public health concerns. So what does that all mean now that we have this pre-market review power in the context of the ongoing harm reduction discussion that is taking place in certain circles here in the United States related to public health and tobacco control? Well, there's this thing called the continuum of risk. There are more harmful and less harmful ways to get your nicotine. And there can be disagreement over where to place smokeless tobacco, or where to place heated products, or e-cigarettes on that continuum. But there's no disagreement about what the anchor points are. The most harmful form of nicotine delivery is the combustible products, cigarettes and cigars. And the least harmful form of nicotine delivery is medicinal nicotine, FDA approved, over-the-counter nicotine gum, patch, and lozenge. So the continuum of risk is a real and relevant concept. And the hypothetical pack-a-day smoker who somehow is able to completely substitute all of their cigarettes with e-cigarettes will definitely be reducing risk, and probably significantly if it's complete substitution. But I laid out the pre-market review framework for you, and these decisions are not made based upon some principle like the continuum of risk or categorical determinations. The law makes clear that the burden is on each company on a case-by-case, product-by-product basis to demonstrate to the regulators at FDA that the benefits outweigh the risks. So what that leaves us with is a whole bunch of inconvenient truths for both sides of the harm reduction debate and for certain members of Congress as well. For those who are so virulently opposed to e-cigarettes, the reality is that certain heated, smokeless, and even e-cigarette products do meet the appropriate for the protection of the public health standard and have earned and deserved the marketing authorization that they've gotten from FDA. And that even includes a so-called very low nicotine cigarette. Some of these products, heated, smokeless, and the very low nicotine cigarette, met an even higher burden, have gotten authorization to make claims to reduce exposure and harm. And more marketing authorizations are certain to follow. But for the proponents of e-cigarettes, there is the reality that so far, when it comes to flavored e-cigarettes, the companies have failed on a case-by-case basis to pass the same test. They simply have not been able to make the case for benefits, which is where the scientific review starts. So if a proposal comes in with marketing restrictions or youth access restrictions, that's great, but so far those have been completely insufficient to overcome the deficiencies earlier in the review process when it comes to proving benefit. FDA has issued negative orders for many flavored e-cigarette products, and once those decisions are made, a company can sue the agency. 48 different lawsuits have been filed against FDA decisions that were made on my watch as center director in 10 different federal appellate courts. 4 of those courts have already ruled on the merits. 3 of them sided with FDA. The 4th sided with the industry in a split decision where there was a dissent that was very strongly supportive of what FDA did. So what does this all mean for the future? And as I said, I don't have a crystal ball, but I do have some thoughts that I am now a little freer to share in public. So let's start with one of the potential so-called endgame notions, reducing nicotine levels in combustible products. What if combustible products, cigarettes and many cigars, what if they could no longer create or sustain addiction? Well, FDA absolutely has the authority to do this, and my opinion is that the regulatory science, thanks to a lot of people in the field that have been at work in studying nicotine reduction over the last 20 years, we have the answers that we need, and I believe that the regulatory science supports it. And the Biden administration just a few months ago announced its support for mandated nicotine reduction in combustible products. And on the day that that announcement was made in June of 2022, FDA Commissioner Califf said lowering nicotine levels to minimally addictive or non-addictive levels would decrease the likelihood that future generations of young people become addicted to cigarettes and help more currently addicted smokers to quit. How could that happen, and what would that look like? And for that, we have the incredible work of you modelers out there to help us paint a picture through the end of the century of what the population level public health impact would be from this one policy. We sponsored some with expert elicitation where the assumptions that were built into the model were created by independent experts with no input whatsoever from FDA, which then drove the model. And we published the results of this in the New England Journal a few years ago. The key is that these these projections had to go out through the end of the century because we needed to know what the generational return on investment from a public health perspective would be. But through the end of the century, from this one policy, more than 33 million Americans who would otherwise have gone on to become regular smokers wouldn't. This would result in an adult smoking rate below 1.5%. And you add all of that up, and according to the model that was published a couple of years ago, that's more than 8 million tobacco-caused deaths that would be avoided. That's not cases of illness. That is 8 million deaths that would be averted by this one policy. So the potential positive public health impact of this is almost beyond imagination. But it raises really important questions about nicotine, because we still have more than 30 million smokers in the United States. Their brains have been rewired by the combustible products that they're smoking, and their brains, and more importantly, the nicotinic receptors in their brains, they don't know from FDA, and they don't know from rules. They don't even know from cigarettes. They just know what the tobacco industry knew 60 years ago, which is those receptors are seeking the next dose. And if they don't get the next dose, and get the next dose fast, they're going to start sending signals to the body, and people will start experiencing the symptoms of withdrawal. And we know that many of the 30 plus million smokers will continue to seek nicotine. So what are the implications for all the other products? The alternative and the less harmful nicotine delivering products that are not part of this proposed policy. This is a policy aimed only at combustible products. We are not talking about altering the nicotine levels in smokeless, heated, or ENDS products. And over the years that I was center director and participating in and watching what was becoming an increasingly divisive debate, especially here in the United States, in my public talks, I started posing a series of questions in what was ultimately an unsuccessful attempt to reframe the debate, but I tried. I reduced it to a short article in Nicotine and Tobacco Research a few years ago. And let me walk you through the questions. The first is, and this is a societal question, and we talked about this in a class I spoke at earlier this morning. How comfortable would we be with long-term and possibly permanent use of less harmful mechanisms, products to deliver nicotine for adults, if that's what it takes to keep a whole bunch of currently addicted smokers from lapsing and relapsing to combustible tobacco products? This really goes to the heart of what is the ultimate objective here? Is the ultimate objective a tobacco-free society? Or is the ultimate objective both a tobacco-free and a nicotine-free society? And that's a discussion, and that's a debate that we need to have. And the second question relates to the first, because if it turns out that a whole bunch of current smokers need to be on these other products for a very long time, and possibly forever, to avoid relapsing to the most harmful product, are we okay? How much weight should we be with diminished interest in quitting nicotine if a whole bunch of smokers have successfully transitioned away from the most harmful products? The next two questions relate to so-called dual use. A smoker that experiments with an e-cigarette, for example, and winds up using both products, continuing to smoke while also vaping. The first of the questions is the easier of the two. So given the potential health impacts and the unknowns, the long-term unknowns about dual use, are we okay with a short period of dual use for those that are transitioning to less harmful nicotine-containing products? The second of the dual use questions is harder. What if there's a whole bunch of current smokers that have to engage in dual use on a long-term or permanent basis to avoid the lapse and the relapse? Are we okay with that? The fifth question is about a category of products that we have only mentioned in passing, and that is medicinal nicotine products. What can we do basically to make them better? They're safe, they're effective, but very few people use them, and they're not terribly effective. The gum, the patch, the lozenge. But they're so safe that they're available over the counter. What can we do to make the products better, either through changing the indications for the products, changing the label, or actually improving the performance, the nicotine delivery of the products? And then finally, kids. if we start making all of these other changes, what about youth initiation? If it's a marketplace for nicotine where addictive levels or potentially addictive levels of nicotine are available here, but they're not available there? And how are we to think about and account for youth uptake of these products? So a few reflections on the current debate, and then I will close. As I said, inconvenient truths for everybody involved in the debate. On the one hand, in a properly regulated marketplace, there is a role for these alternative products, whether it's some of the heated products, the smokeless products, even the e-cigarette products, and maybe one day flavored e-cigarettes. And the reality is, as far as I'm concerned, some people may need to stay on these less harmful forms of nicotine for a long time, possibly forever. So I think that profound question of is it tobacco-free or is it also nicotine-free is a really important one. On the other hand, I've laid out the law for you. And the burden of proof is on the companies. And the reality is that kids like flavors. Kids should not be using any of these products. Now that we have pulmonary delivery of nicotine for the first time without combustion, we're dealing with a form of nicotine that could make the nicotine more addictive than if it's delivered orally or dermally. And it's clear that the past marketing practices, both of cigarette companies and some e-cigarette companies, absolutely targeted kids. So I'll ask you, when was the last time that any of these truths were acknowledged by those who find either set of them inconvenient? And I think that the times that those acknowledgments occur are rare. For the most part, and especially when it comes to the loudest mouths in the field, I don't see any interest whatsoever in seeking common ground, even on matters of principle. There's a lot of noise, especially on social media, but it's an echo chamber. It's not moving the needle on anything. It's basically people on one side or the other preaching to the choir. So I'll leave you with 5 new questions. So what's it going to take to change all this? And all of us involved, either as researchers, advocates, policymakers, we need to figure out how to change things up. What about the endgame notion, starting with mandated nicotine reductions, a world where these combustible products could no longer create or sustain addiction? Is that something that we can agree to? And if not, there are other endgame approaches. Is there some other endgame approach that can sort of rally the troops and bring us together? And if not, well, what about some principles that could help sort of drive our day jobs? Principles that the combatants could agree to. And can we get a commitment to seeking common ground? So far, that common ground has completely eluded the fields of public health and tobacco control. So I'll close on a note of optimism, because I choose to remain an optimist on all of this. And I had searched for a quote on optimism, and I came across one from a very, very unlikely source, and that is probably the greatest playwright of tragedy in the 20th century, Eugene O'Neill. And the greatest tragedies that O'Neill wrote were about addiction. Addiction to drugs, addiction to alcohol. And so when we think about Eugene O'Neill, we don't necessarily think about optimism. We think about just like the worst that could happen to the human condition and the tragedy that comes with it. But O'Neill said, I am so far from being a pessimist. On the contrary, in spite of my scars, I am tickled to death at life. So I'll leave you with that, because if Eugene O'Neill could maintain some optimism, with all the scars on my back from the last 28 years, I have no choice but to maintain the optimism as well. Thank you very much.
Thanks so much, Mitch. A very, very provocative, insightful, uniquely experienced presentation, and you met and exceeded all expectations. I'm also glad that your glass remains half full, and I think that you've lifted the content of our glass here, which is important. So look forward to having some further discussion. Let me move now quickly, in the interest of time, to introducing our respondent, Jamie Tam. Dr. Jamie Tam is an assistant professor in the Department of Health Policy and Management at the Yale School of Public Health, where she conducts research on the effects of tobacco regulations, using simulation modeling methods to understand domestic and global tobacco use disparities with a special focus on populations with behavioral health conditions. And by the way, while we won't be focusing particularly on that today, people with comorbid mental health and substance use disorders constitute somewhere in the neighborhood of 40 to 50% of all smokers in the United States. So this is just a tremendously important area that Jamie is helping lead research in. Her current work uses modeling methods to examine the impact of tobacco control policy interventions for people with major depression and other vulnerable groups. She's an investigator with CASTOR, as well as the NCI-funded Cancer Intervention and Surveillance Modeling Network. Prior to joining Yale, Dr. Tam was a tobacco regulatory science fellow at the FDA's Center for Tobacco Products under the venerable Mitch Zeller. She received her MPH and PhD in health policy here at the University of Michigan School of Public Health. And I'm proud to add, and have to add, was once upon a time, a long time ago, a student in my tobacco policy course here. And we are just delighted to have you back, Jamie, to provide your remarks.
Here we go. All right. Thank you for your presentation, Mitch. And thank you to Castor and to Cliff for inviting me to come back to Michigan for this special event. I'm very happy to be back in Ann Arbor. Now, many have wondered why tobacco control progress is so slow at the FDA. What are the challenges FDA is facing now? How could that progress come sooner? I have some ideas, and I'll follow with some questions, and I hope that they prompt a rich discussion to follow. Now, what exactly do I mean by progress? Two kinds. The first kind is progress in the form of product standards that make cigarettes and other combustible tobacco products less addictive, less appealing, and less harmful. But product standards have to go through the rulemaking process. First, with a notice of proposed rulemaking, an NPRM, or sometimes an ANPRM, an advance notice of proposed rulemaking. These are published in the Federal Register for public comments. Then after analyzing those comments and making further revisions, the rule is finalized in the Federal Register once again with a specific date when that rule will go into effect. Earlier this year, an NPRM was published that would aim to prohibit menthol and other flavors from cigarettes and cigars. But so far, FDA has yet to finalize a major product standard that would transform the combustible tobacco marketplace. The second kind of progress is in the form of FDA marketing authorizations that make less harmful alternatives like e-cigarettes more available and acceptable to users who want to switch to them, while also not being appealing to youth. So far, the FDA has denied marketing applications for flavored e-cigarettes and has only authorized a handful of e-cigarettes that are tobacco flavored, impacting their appeal and acceptability to users who want to switch to them. These marketing decisions, even though they're made individually on a case-by-case basis with each company's application, they become de facto national policy on e-cigarettes as an entire product category. So the availability and acceptability of e-cigarettes as a cigarette substitute is likely to change as FDA continues to make decisions about which e-cigarettes and whether flavors are allowed to stay on the market and which are not. Okay, so I'll jump now to what I've listed as 5 challenges. The first challenge is bureaucratic in nature. A lot has to happen before an NPRM makes it into the Federal Register. The Office of Regulations within the Center for Tobacco Products has to draft the proposed rule, determine the legal basis and justification for the rule, which is super important if the rule ever wants to survive judicial review. They have to consider all possible alternatives and then solidify the rationale for each proposed provision of the draft rule. In addition, a cost-benefit analysis has to be conducted to determine the economic impact of the rule. Then this language and its rationale has to go through multiple levels of clearance. First within the Center for Tobacco Products, CTP, then at FDA, then at HHS, the Department of Health and Human Services, and then with the Office of Management and Budget within the President's Office. The OMB coordinates review by other additional federal agencies. So even more federal agencies are involved in the review process beyond HHS. And so with these numerous bottlenecks in the process, and these clearance procedures are time consuming and very vulnerable to slowdowns. It is a slow, painful, stop and go, winding road to the Federal Register. And the process is also not necessarily linear, as drafts are revisited and returned to the other offices. So given that there's considerable rulemaking oversight through the OMB from the President's office, politics can dictate the pace of progress. If there's substantial political willpower, things can move much faster. But the absence of that means that proposed drafts can lay dormant for really long stretches of time, even years. Another reason for slowdowns at the FDA might simply be due to its limited capacity. When you consider the sheer number of tobacco products under FDA's purview, for these products to each be reviewed individually by the agency requires a large workforce comprised of scientists with the technical expertise to evaluate the products. Perhaps the workforce at CTP actually needs to be larger than it is today. When tobacco manufacturers submitted applications for substantially equivalent tobacco products a few years ago, this led to a backlog of thousands of applications that were waiting for review. FDA is currently in the process of reviewing millions of e-cigarette product applications as well. Now, all of this work is funded by tobacco company user fees. These fees make up the budget at CTP, and cigarette manufacturer user fees in particular represent 86% of CTP's annual budget, with the remainder covered by cigars and smokeless tobacco companies. So despite the massive labor burden of regulating e-cigarettes, e-cigarette companies have not been contributing any user fees to the FDA, leaving the agency potentially under-resourced to regulate both e-cigarettes and the other tobacco products under its purview. This is a byproduct of the TCA, which was signed in 2009 when e-cigs were still relatively new. So e-cigarettes were excluded from the tobacco user fee framework. What that means then is that all the regulatory activities coming out of FDA that we've seen so far are around e-cigarettes, which are less harmful and are funded by user fees that were originally intended to regulate cigarettes, the most harmful products. Of course, litigation is a disruptive and constantly looming threat to the agency. Industry litigation directly impedes progress. And as one example, R.J. Reynolds successfully sued in 2012, and the graphic health warnings that the FDA originally issued more than a decade ago were struck down. But although disruptive, litigation can sometimes actually accelerate progress in specific areas. So when the FDA did not issue new graphic health warnings, public health groups successfully sued, and FDA was ordered to issue a new set of graphic health warnings in 2020. Public health groups have also successfully sued the FDA to force them to move forward with their review of premarket applications from e-cigarettes and to propose a menthol flavor ban for cigarettes. But even after a rule gets finalized, as with graphic health warnings in 2020, industry can use the courts to postpone the effective date. And by my count, the implementation date for graphic health warnings has been pushed back 8 times. They will supposedly go into effect in fall of 2023, but who knows? These delays cost lives. If graphic health warnings had been implemented as originally planned in 2012, this would have translated into an additional 179,000 premature deaths averted and 3.3 million life years gained through the rest of the century, according to my research group. All right. Considering how long it takes for FDA to issue and finalize a rule, the rulemaking process ends up spanning multiple years and administrations. Twice each year, in the spring and the fall, all planned regulatory activities are published in the Unified Agenda. So a look back at all tobacco activities in the Unified Agenda gives us a sense of the time span for rulemaking. During the Trump administration, Commissioner Gottlieb announced plans to potentially reduce nicotine levels in cigarettes through an ANPRM, and this is in the pre-rule stage, that was eventually published in the Federal Register in 2018. By spring of 2019, the nicotine product standard had moved from being in the pre-rule stage to the proposed rule stage, but this was followed immediately by Gottlieb's departure from the FDA. So rulemaking is routinely interrupted by changes in leadership and administrations. Changes at these critical junctures mean that momentum gets lost. But the pursuit of any product standard is always going to extend well beyond the time of the leadership currently in office. The Biden administration, with Robert Caleb as the new FDA commissioner, has announced its plans for both a menthol ban and for cigarettes and combustibles and nicotine reduction. But we need to look out for that, because election season and commissioner appointments are going to be key opportunities and impediments to progress going forward beyond the Biden administration. The last challenge I'll mention is the science the FDA uses to make its decisions about which e-cigarettes are allowed to be on the market. As Mitch mentioned earlier, the burden is on each company to demonstrate that the benefits of their products outweigh their potential risks. Well, which e-cigarette products and their flavors get to be on the market are ultimately determined by the company's science and what they submit in their applications. Most e-cig companies have failed through their science to demonstrate the benefits of their products. More than 1 million e-cigarettes have received marketing denial orders from the FDA, and only a small number of companies have the scientific resources to demonstrate the benefits of their products to the FDA. But FDA communications suggest that outside science can influence decisions. Given deficiencies in manufacturer science, when or how does outside research influence scientific review of specific e-cigarette applications? So I'll leave you with 5 questions that I don't necessarily have answers to add on top of Mitch's 5 questions as well, or 6 questions if I'm right. The first is, can rulemaking be made any faster? What can be done to streamline this process and make it more efficient? The second is, how might FDA's limited capacity to regulate products be addressed by e-cig user fees, something that's only possible with legislative action? What can we learn from FDA's experience with litigation, both from the industry side and the public health side? And as for product standards, what can be reasonably achieved under the Biden administration, and how might the 2024 election alter that trajectory? Finally, what kind of research influences e-cig decisions? Does the scientific community need to shift the way it does research and consider brand-specific research rather than evaluations of e-cigarettes as an entire product category? Or are there unrealistic expectations about the extent to which outside science from the academic community or public health community, about the relevance of that outside science to pre-market review? So thank you for listening, and I think we'll go ahead and shift into the Q&A section.
Thanks so much, Jamie, we appreciate the thoroughness of your presentation combined with efficiency, which was, I thought, rather remarkable. So, while we assemble some of the questions that might be coming in, I thought, Mitch, that I would just start by turning to you and really just giving you kind of an open opportunity, given all of the thoughts and feedback that Jamie has just provided, for any initial thoughts you might be having, because I could just see you thinking while we were sitting there together.
Well, I think that Jamie did an excellent job of pointing out the reality. The reality of what it's like to try to do regulation through the rulemaking and application review process. And in hearing her make those, I think, very relevant points, what it reminded me of is a talk that I went to the first year that I was working on tobacco at FDA in 1994. 1994 was the first time that FDA ever went to the World Conference on Tobacco and Health, which was in Paris that year. I represented the agency with one other person, and a dear colleague who's no longer with us, John Slade, was sort of taking me from session to session, telling me which session I should go to, because in 1994 we were just starting to gather up the information. And he said, very important that you go hear Nigel Gray talk. And Nigel Gray, for those of you who don't recognize the name, is really the godfather of global tobacco control. He started working on tobacco control in the 1960s. I didn't know who he was. I was just told, go and listen to this guy. And I went to Nigel Gray's lecture in 1994, 6 months into our investigation, we were going to change the world, and we were going to do it quickly. Everything was on our side, the evidence, everything that I laid out in the talk. And this was Nigel Gray's message in 1994, based upon what at that point was close to 30 years of work in the field for policy change. Nigel said, given who and what we in tobacco control are up against, he said he has learned the hard way that the yardstick by which to measure progress or not is in increments of decades. Decades. He said, this is so hard that sometimes the hardest stuff can take at least 10 years to make happen. And I remember sitting in that audience, not buying one word of what he was saying. But he was right. He was right. And Jamie's right. What we do at FDA is super hard. And even in enlightened administrations, it's hard. And the most game-changing of the potential policies require support, conviction, courage, and a will to see it through. And sometimes that support is there, and sometimes it isn't. But for those of us with thick enough skin, it's worth trying, even if, because I think Nigel turned out to be right, even if the progress on the truly important stuff can take a very long time. We're not talking about a product that just has some incidental impact on public health. In the United States, we're talking about a product that is still the leading cause of completely preventable disease and death, even with the historically low adult and youth smoking rates that we have. However long it takes, I think it's worth the effort.
Thanks, Mitch. You know, Nigel Gray was from Australia, and it may have been at the same World Conference that I recall his giving a plenary address. And he said something profound there that was very basic and simple in its sense. But he was, for the first time, speaking publicly and advocating, so it was a long time ago, on behalf of the concept of reducing nicotine to non-addictive levels in cigarettes. And he said, the status quo is not acceptable. And that might seem obvious, but it's something that you, I know, and many of us have been struggling with for a very long time. To not accept the norm that's existed for so many decades around this epidemic and the death and illness that occurs annually in this country and everywhere else. One very basic question came in, by the way, and it has to do with something you touched on, which was the comprehensive plan that you and Dr. Gottlieb announced in 2017, which posited this concept of, interfering with the on-ramp to combustible tobacco use and addiction, while looking toward the opportunity for creating or supporting a more robust off-ramp for those tens of millions of addicted adults that might involve a variety of things. Cessation, obviously, the opportunity to move toward down the continuum of risk to alternative products. And the basic question is, given the environment that we've been in these past few years, how do we get back to the 27 plan, and is FDA, in your view, heading in that direction at this juncture?
Well, I can't speak for the agency anymore. I'm not there. But I can speak for myself, and I can tell you on the outside looking in where I see the opportunities. I absolutely continue to believe in everything that we laid out in 2017 for the regulation of tobacco and nicotine. But some things have changed since then. When we laid it out, we were in the middle of a 2-year decline and leveling off of kids' use of e-cigarettes. And then 2018 happened. And we saw an explosion in kids' use of e-cigarettes. Coupled with, Jamie referred to litigation brought not by the industry, but by the public health community. Coupled with litigation that the public health and tobacco control groups successfully brought against the agency in 2018, which resulted in a decision in 2019 where instead of us having 3 more years before the applications for e-cigarettes would be due, the court ordered that those applications were due in 10 months. Because critical to what Gottlieb and I laid out in 2017 was time. Time to put the foundational rules in place, the guardrails, if you will, for applications and important procedural issues that are the guts of what a regulator does, but also time to follow through on and make nicotine reduction happen. And everything got greatly accelerated when FDA lost that lawsuit. So in 2022, especially since the Biden administration has signaled its support for mandated reductions in nicotine levels in combustible products, I think that the opportunity is there to make the framework that former Commissioner Gottlieb and I laid out in 2017 more and more of a reality. I think that nicotine reduction is a cornerstone of that, but it is by no means the only piece of the puzzle, but it's a super important piece of the puzzle. Jamie made the important point that things changed after Gottlieb left, because it was the Trump administration after all, and that's absolutely right. When Gottlieb left, it was a step backwards in advancing all of this. But now it's the Biden administration, and there's an opportunity to start and complete a rulemaking that would be transformative when it comes to the most dangerous form of nicotine delivery. Cigarettes would still be incredibly toxic. We're not talking about the safer cigarette. There's no such thing as a safe cigarette. But the industry in those previously secret documents had identified young people as replacement smokers. Think about it. Young people to the industry were replacement smokers for addicted adult smokers who died or quit. And that's why we did the modeling on a generational basis. Because what happens if future generations of those replacement smokers who will experiment with cigarettes, every generation of teens will engage in risky behavior. But what if the cigarette or the mass-produced cigar of the future, as dangerous as it would be, is no longer capable of creating or sustaining addiction? That's game-changing. But what comes with that is a responsibility to address alternative and less harmful products.
Just to add to that, I think it's hard to not ask the what if question. Like, what if that hadn't happened in 2018? What if there wasn't a sudden, surge in youth vaping? Or what if the public health litigation hadn't forced FDA to expedite its review of all these many e-cig applications? Would more progress have been made? Would Gottlieb have stayed commissioner? Like, there's so many questions. But I think you're right to sort of pivot. We can keep asking the what if question, like how might things have played out differently if all those events didn't take place in 2018? But it's already happened. And so now we have to sort of accept the reality that FDA is bogged down by all these e-cig applications, that a lot of agency like resources and capacity have been shifted over to regulate e-cigarettes. And now we're, I guess the upside to all of it is that the Biden administration is so positive.
Well, I'll challenge one thing that you said, Jamie. Yeah. So the industry submitted a total number of applications for 6.7 million products. And on my watch, not to be defensive, on my watch, we took final action on all but 50,000 of the 6.7 million products. Now, granted, in that remaining universe of 50,000 products were a number of applications from companies with the largest market share, and the agency continues to make decisions on those applications, but some of them still remain undecided. But I think that the agency and the center showed that it was up to the task when instead of 3 more years, it was 10 more months to take final action and to do as well as the agency is doing in court is a sign not of an agency and a center getting bogged down, but an agency and a center that rose to the occasion despite the criticism that is coming from one side for not taking more aggressive action on the remaining products, and on the other side by suing us in 48 different cases in 10 different federal. They can't both be right. And so far, the courts are mostly siding with FDA. But there is still work to be done on those remaining tens of thousands of products.
A couple of other questions have come in. One is a short one, but one that could have books written about it, I suppose. Some other countries are managing these issues in some different ways. The ones that immediately come to mind would be the UK, New Zealand, looking at endgame approaches. You've touched on the concept of endgame. And the question is, what lessons have you taken or are you taking from outside the US and why? What are your thoughts around that in comparison to what's going on here? There are obviously differences in system, in jurisdictions, et cetera, but what might your thoughts be in that area?
Well, first and foremost, it's what New Zealand is doing with nicotine reduction. If they do it, they would be first. And it's the perfect natural experiment because it's New Zealand after all. So I think that there's a lot that can be learned from, can they get it across the finish line? And then what does the world for cigarettes look like in New Zealand after that's a final action? For countries like the UK, for me, it's not so much lessons learned, it's almost envy. I have a lot of friends and colleagues in the tobacco control and research communities in the UK that I've spoken to over the last 20 years. And unlike the US, where we have these pitched camps within the world of advocacy, research, and the politics that comes with it, there's a really interesting alignment in the UK between where most of the researchers are, where most of the advocates are, and where government is. And so we're not going to be able to replicate that in the US. It is what it is here, but I am somewhat envious that the environment in which policy is getting made in the UK, whether you agree with it or disagree with it, it's taking place in a country where, for whatever reason, there is a much more open-minded and enlightened view when it comes to harm reduction. And it didn't start with e-cigarettes, because I spoke regulator to regulator to MHRA, the medicines agency in the UK, when I was on the outside, before I came back to the agency, trying to change FDA policy on those medicinal nicotine products, to change the labeling, to change the indications, and maybe even to improve performance of the products. And years ago, decades ago, the FDA equivalent in the UK was much more willing to alter the indications and the labeling for the very same medicinal nicotine products so that more people would try to use them. And it was that kind of open-mindedness to harm reduction and the resulting change in, well, how much evidence would be needed to satisfy the regulator, that is a type of policy change in the UK that sadly still has not happened for medicines regulation in the United States. And let's just say I got to see it up close and personal in my 9 years that I came back to the agency as Tobacco Center Director.
Thanks. I'm delighted we have a live question. Kara Kiesling.
Yeah, absolutely. This is a question from the audience. When does a product require a prescription? And is there a future with very low nicotine combustibles alongside nicotine products that requires a prescription only available to former combustible users, like some sort of combination?
Could you repeat the first part of the question?
When does a product require a prescription?
So, you know, a lot of people have asked, well, why can't e-cigarettes be regulated as drugs, either as RX requiring a prescription or over the counter? Now, here's the history. That's what FDA tried to do before this all got out of control. In 2007, 2008, and 2009, FDA tried to restrict at that point, e-cigarettes were only being manufactured in China and imported from China. FDA declared that e-cigarettes were unapproved drugs and tried to prohibit the importation of e-cigarettes, which, if they had prevailed, would have forced e-cigarettes to, if they were going to get to market, to come through the drug authorization process. Again, RX versus OTC, the distinction doesn't matter. It's could it and should it have been regulated as a drug? That's what the agency tried. 2 importers successfully sued the agency, and by the time that case went up on appeal, the Tobacco Control Act had passed, and the DC Circuit ruled that the only way that FDA could regulate e-cigarettes under the drug provisions is if a company made a treatment or cessation claim. And there are no e-cigarettes that are making treatment or cessation claims. They may be making harm reduction claims or other lifestyle claims, but that doesn't cross the line into what the court said would make it an unapproved drug. Otherwise, the court said the only way that FDA could regulate e-cigarettes in light of passage of the Tobacco Control Act was as a tobacco product, which sounds counterintuitive because there's no tobacco in e-cigarettes. But it comes down to what was then the statutory definition of a tobacco product, which was anything made or derived from tobacco. And until the more recent popularity of so-called synthetic nicotine or non-tobacco derived nicotine, the nicotine in e-cigarettes only came from tobacco, and the court said that, therefore, that's the only way that FDA could regulate them as tobacco products. Having said that, if an individual e-cigarette company wanted to come to market as an RX or over-the-counter drug, it can. But they have to go through the drug approval process, not at the Center for Tobacco Products, but at the Center for Drug Evaluation and Research at FDA. And I can neither confirm nor deny that conversations between companies and our sister center have taken place. If those conversations have taken place, it's completely non-public. It's between the company and the regulator. But it is a fact that there are no FDA-approved e-cigarettes as cessation aids. But that wouldn't stop a company from filing a new drug application to try to get one authorized. And there was a second part, which I've forgotten.
Second part of that is there a future with very low nicotine combustible products alongside nicotine products that require prescription only available to former combustible users?
I think the answer is yes, and not just theoretically or hypothetically. We have RX cessation aids. Now, some of them don't contain any nicotine, but the so-called nicotine inhaler, which doesn't really get any of the nicotine into the lungs, but you do try to inhale it. That's a prescription product. It's not a great product, but it's been on the market for a very long time, and we already have the very low nicotine cigarette that was authorized by CTP on my watch, possibly with more of those kinds of products to come. And what happens if this product standard is finalized, where all combustible cigarettes and mass-produced cigars would contain minimally or non-addictive levels of nicotine, and they would sit alongside FDA-authorized RX or OTC nicotine-containing products. But I think maybe more importantly, they would be sitting alongside higher nicotine alternative tobacco products, whether it's heated, smokeless, or e-cigarettes.
So we are pushing the time limit right now. Let me finish with just one final question for you, Mitch, and it has to do with the marketing side of all of this. We have talked a bit about that, a lot about product and what the products contain and deliver. The question here is, in your years dealing with tobacco issues, you've seen many fights over particular big tobacco marketing schemes. So you think of the Marlboro Man and Joe Camel back in the early 90s, billboards, sports sponsorships. Richard Miek alluded earlier to the changes that took place after the master settlement was adopted. Tobacco control, our community, fought those schemes because they were seen as attracting kids, and they were, to smoking. So the question here is, isn't this part of how FDA can effectively respond to the concerns around youth when it comes to vaping products by placing strict marketing restrictions on authorized products? So when you look at whether a product is appropriate for the protection of public health, how does that come into play? And is that an answer to some of the concerns, even around flavors and other things?
I think the answer is forward-looking, potentially yes. But first, if we're talking about application review, as I said in my talk, you don't get to talk about the marketing restrictions if the company hasn't been able to make the case for demonstrable benefits and the benefits outweighing the risks. But hypothetically, what if the manufacturer of a flavored e-cigarette company comes along and they are able to prove that the benefits to adults outweigh the risk to kids? Then the agency would take a long and hard look at marketing restrictions and access restrictions, and then some additional sort of reassurance of minimizing the unintended consequences of authorizing a flavored e-cigarette product for the first time could be addressed through really aggressive marketing and access restrictions. The one example that that people tout, but so far is not present in any currently marketed e-cigarette product in the United States, is a lockout device, a true lockout device, where even if a kid could get his or her hands on the product, there would be some kind of technology built into the product that would prevent that child or adolescent from turning the product on. That is a technology that is not currently available in any currently marketed e-cigarette in the United States. I think it would be an interesting case, again, purely hypothetically, if the manufacturer of a product like that met its burden on the benefits side and had that kind of technology built into the product. I think that would be a very interesting discussion that I will no longer be privy to at FDA for the regulator to try to sort out. The other thing that I would say, which is like a corollary, which is something more proactive for the agency, and something that we did a lot of on my watch, is compliance and enforcement actions against those products that are blatantly being marketed to kids. And sadly, we had to issue many hundreds of warning letters to manufacturers, retailers, online retailers and manufacturers that were selling products that were, blatantly marketed to kids. And perhaps the worst example that I saw was hoodies and backpacks with stealth pockets and stealth drawstrings that were able to disguise vaping, so that a kid could insert an e-cigarette into the drawstring or into the backpack strings, vape, and it just looked like they were doing something with the strings or parts of the back. When we saw this, we thought we'd seen it all until that product was on the market. To me, that was, in some respects, even worse than products that were deliberately designed to mimic Game Boys or other kids' toys and devices. And you put the original product and the e-cigarette device side by side, and you'd be hard pressed to tell the difference. Back when fidget spinners were really popular, someone came up with a fidget spinner vaping device for kids. So there's a lot that the agency has done, and unfortunately will continue to do proactively to try to get the most reprehensible products off of the market.
Thanks for that. And unfortunately, we also have to wrap up our discussion. Thank you for hanging in there a little bit over time, folks. This has been worth every split second that we've experienced. Next time, we'll have you for 5 hours. And I want to thank Jamie Tam very much again for joining us. The whole team from Castor Institute for Social Research, Richard Miek, and all of you for joining us. And then I have to extend a special thanks in particular to Amanda Dudley, because Amanda, as the project manager for Castor, has made this whole thing happen today. So thank you so much.